This summer, the hostilities between New York State regulators and the online prediction market Kalshi ramped up, with the state attorney general suing the company in July, claiming their business practice, which allows you to buy yes or no contracts on sporting events and other everyday outcomes, violate state prohibitions on unlicensed gambling. The legal action comes in the wake of state gambling regulators calling for Kalshi to cease and desist their de facto sports gambling operations back in October of 2025, and after New York's Attorney General went after prediction markets Gemini and Coinbase in the spring of this year for unlicensed gambling operations. Kalshi has claimed that New York is overstepping with its lawsuit, arguing that prediction markets are under the jurisdiction of the U.S. Commodity Futures Trading Commission, but a handful of other states have already won restrictions on the operations of prediction markets. For more on this drama, we're joined on the Capitol Press Room by attorney Daniel Wallach, who specializes in gambling issues. Well, New York's Attorney General has argued the event contracts offered by prediction markets like Kalshi, where, for listeners who might not be familiar, allow you to weigh in on sporting outcomes and a whole host of other everyday outcomes, are quintessentially gambling. And they're doing this without a license, which is required in the Empire State. Is there a test in New York for what constitutes gambling, or is this one of those areas where if it walks like a duck and quacks like a duck, it's probably a duck?
Both. New York defines, gambling as it encompasses both games of chance and, or in some cases, games of skill, like pari-mutuel wagering on horse racing. That's a game of skill, but it's regulated as a form of gambling under New York State's Constitution and the New York Legislature. But the broad test for gambling is essentially staking or risking something of value on the outcome of a future contingent event, which the contestant does not influence or control. That's the New York penal law definition of gambling. So, Kalshi's sports event contracts are the future contingent events associated with sporting events. You wager or risk or stake something of value, and then you win a prize if your prediction comes true. Now, Kalshi's attempt to distinguish sports event contracts from traditional gambling, I think, runs aground on the idea that gambling can only be against the house. And what Kalshi is offering through its sports event contracts is a true peer-to-peer model, where your counterparty on the contract is another person just like you.
Yeah.
But that argument does sort of ignore that many forms of gambling are peer-to-peer in exchange wagering type formats like pari-mutuel wagering and horse racing. And then, of course, Kalshi and a number of the other prediction market platforms have affiliated trading companies, institutional market makers, such as
Right.
Susquehanna International Group, Kalshi Trading, its own wholly owned subsidiary. They're making the markets on these bets, and your counterparty isn't David Lombardo or Daniel Wallach. It's a hedge fund.
So while what you described there sounds a lot like traditional online sports gambling, the whole debate does remind me of the legal fight in New York that started about a decade ago over daily fantasy sports and whether those contests constituted gambling. Ultimately, the state's top court bought the argument from the legislature and daily fantasy sports companies that the games were separate from gambling because they were more reliant on skill than chance. In this case, then, why shouldn't the courts get equally in the weeds with what is happening and treat prediction markets, which are regulated by the federal level, as something unique from gambling? If something that, if you go by the very letter of the what they're doing and what they're claiming to do and the federal oversight that's in place, why shouldn't the courts say, yeah, this is different from gambling?
28 out of 34 courts across the country have issued judicial rulings. States such as Michigan, Ohio, Southern District of New York, the vast majority of which, over 80%, have concluded that this is subject to state gambling regulation. And the decision has at least implicitly been made by these preliminary rulings that have cast sports related event contracts as virtually indistinguishable from sports gambling. And as such, the state laws and regulations applicable to gambling apply. Now, the courts are not assessing whether it's illegal gambling yet. That's the role of the state court system. The federal court system has analyzed a narrow issue, whether the Federal Commodity Exchange Act preempts, ousts state gambling regulations with respect to sports event contracts. And necessarily, these federal and state courts around the country have been concluding in increasing numbers that this is a form of gambling activity that is to be regulated, or that there's a role for the states to regulate this as gambling activity. So the courts are diving into the weeds. A Michigan federal court judge issued a 44-page ruling on Thursday, preceded by a Utah federal court ruling that exceeded 30 pages. Deep dive on whether the Commodity Exchange Act expressly, impliedly, or conflict preempts state law. And the judgment of almost all of these courts is that it does not oust states from regulating it as gambling activity. So going forward, I mean, obviously this is going to ultimately percolate through the federal appeals courts, but ultimately this is a state law issue. And if the states are able to persuade the federal courts that the CEA, or Commodity Exchange Act, does not preempt state sports gambling laws, the next battleground will be in the state courts. Something similar to what you were describing with the daily fantasy sports cases that went all the way up to the New York Court of Appeals. That's where Letitia James wants to go, and Kalshi wants to have a federal court issue an injunction barring her from litigating this in the state court system.
Well, you mentioned the process of federal appeals. Is this ultimately something where the U.S. Supreme Court is going to weigh in on Kalshi and its regulators?
I think the likelihood of that happening is very high, given how divided some of the rulings are across the country. Now, I've mentioned that 28 out of 34 rulings have favored the states, but six have still favored Kalshi. And this is a national exchange through which sports event contracts and other types of entertainment and political contracts are traded by traders across 50 different states. So if you have a fracturing of that 50 state exchange, it does kind of cry out for some, harmony and uniformity in how the federal courts approach this. And the only court in the federal court system that can bring that uniformity to bear would be the U.S. Supreme Court. And it tends to take decisions out of the federal appeals courts where there are splits of authority. Right? So we haven't reached the point yet where there's a circuit split. The only appellate court ruling in the country to date has been from the Third Circuit U.S. Court of Appeals, and they sided with Kalshi. But there are rulings imminent, and very soon we will have a circuit split. So the Supreme Court will ultimately hear one of those cases, either the Third Circuit case out of New Jersey, Ninth Circuit case out of Nevada, Sixth Circuit out of Ohio, or the Fourth Circuit out of Maryland. One of those cases will likely be the vehicle for the Supreme Court to weigh in here and decide once and for all whether the Commodity Exchange Act completely preempts state sports gambling laws with respect to these sports event contracts. And I believe, based on how the court has treated sports gambling in the past, it is, at least in my view, 80% likely that the U.S. Supreme Court will side with the states here. And the reason I hearken back to is Murphy versus NCAA, which was the 2018 Supreme Court decision, which invalidated the federal ban on state authorized sports gambling that was otherwise known as PASPA, or the Professional and Amateur Sports Protection Act. Justice Alito, writing for the majority, stated that if Congress does not directly regulate sports gambling, the states are free to act on their own. This was a 2018 decision. The path that Kalshi is traveling under is this notion that in 2010, Congress amended the Commodity Exchange Act through the Dodd-Frank amendments, and those Dodd-Frank amendments provide a regulatory scheme for sports event contracts. Well, if that happened in 2010, that kind of is at crosshairs with the Murphy decision from 2018, in which Justice Alito logically assumed that there was no federal congressional regulatory scheme for sports wagering. So you've got all these principles and obstacles that stand in the way of Kalshi and the CFTC prevailing. And I think the courts, at least on the federal district court level so far, have understood that argument, and that argument has resonated with a little bit over 80% of the courts that have ruled on this issue so far.
If I'm a policymaker in a state like New York that has chosen to regulate sports gambling, I probably assume that to some degree a site like Kalshi is cannibalizing my existing operators, but to some degree, they're probably bringing in new players, at least those 18 to 20-year-olds who can't even gamble legally on sports gambling in New York. But additionally, there are the other products they offer outside of sports, like politics and culture. So if I'm a state policymaker in New York, am I trying to bring prediction markets into the fold somehow so that I can tax them and get revenue from them? Because we're talking about a multi-billion dollar enterprise here in New York. I mean, is there a pathway for something like that potentially in the future?
I think it's a very narrow, limited pathway, and here's the reason why I don't think it's viable. I mean, you highlighted the fact that they offer that the Kalshi and the other prediction market platforms, not all of them, but most of them allow people to wager on events, pop cultures, sports, politics between the ages of 18 and 20. That's below the legal age to gamble in New York. So that's a non-starter. Okay, just because of the age range. And there's also the issue of the tax rates that are paid on mobile sports betting
Sure.
revenues. The nine mobile sports betting operators entered into a competitive bidding process 4 years ago, a request for proposals process in which they agreed voluntarily to pay over to the state of New York 51% of their mobile sports betting revenues, and the vast majority of those revenues, which have totaled over $1 billion annually in each of the last 2 years, almost all of that is earmarked for public schools statewide into responsible and problem gambling programs. Kalshi doesn't pay any state
Well,
taxes.
do you think that's a
If
deal
they
breaker
wanted
then
to,
for Kalshi? Do you think if someone said, "Hey, you can come into our system, but you're going to have to pay a 51% tax rate," do you think they'd say, "No, I'd rather just operate in other states"?
they'd say no because they want to operate free of any state regulatory constraints, free of any state taxation over a nominal amount. Their argument is they're already regulated under federal law, but I think the leverage here may change as we go further along the continuum and State Attorney General Letitia James starts winning a few more cases and maybe getting into a position where the state gets a preliminary injunction or temporary restraining order, forcing Kalshi to cease offering sports, politics, and culture event contracts. And once that happens, I think the leverage, or at least the perceived leverage on the part of Kalshi, shifts dramatically, and they might have to make a decision here, maybe sweetening the pot or exiting New York for the time being and approaching the state legislature. And there's precedent for this. Over 10 years ago, when the New York Attorney General sued the daily fantasy sports companies for offering DFS contests under New York law without there being any state legislation, New York. And in return, the New York Attorney General agreed to relinquish and abandon its claims for disgorgement, restitution, civil penalties, and damages. And the settlement agreement contemplated that the companies would go to the New York legislature and try to get legislation passed. And if and when legislation is passed, they're welcome back. So the precedent is here for Kalshi to do the exact same thing, which is to relinquish its sports event contracts in New York, as well as the culture and the weather, keep all of their other event contracts, which are not part of this lawsuit, and try to get some legislative change enacted. But to dangle it as a deal where if the state agrees to relinquish its lawsuit, they'll agree to a tax proposal. I mean, it's not up to Kalshi to determine the rules of the road. This has to go through the New York legislature and possibly even a constitutional amendment. We don't know. It's a very complicated scenario in terms of how legislation would be enacted here. But I think the precedent established by the fantasy sports companies is to retreat from New York and try to get legislation passed. And Kalshi is not willing to do that. And until the momentum or the leverage shifts more decidedly in the state of New York's favor, I think it's going to continue to be a litigation until the time when the Attorney General's office wins a TRO and or a preliminary injunction. And I think that's the come to Jesus moment for Kalshi in New York State.
Well, finally, if New York is successful temporarily or permanently in shuttering Kalshi, what does that mean for the people on the service who might have open bets or money in their accounts? Is there going to be, you imagine, a process for unwinding all of that, or could they just be out of luck?
No, they're not going to be out of luck. And I think for a comparator, we have to look to the Massachusetts court ruling from earlier this year. The same scenario occurred. The Massachusetts Attorney General sued Kalshi in the Suffolk County Superior Court. The judge entered a preliminary injunction and ordered Kalshi to unwind its existing contracts, but not accept any new, sports event contracts. So there was a process for an orderly unwinding of existing trades, and the ruling also required Kalshi to implement geolocation technology to ensure that the terms of the preliminary injunction were abided by. So there's precedent here in at least 4 state courts of Kalshi being ordered to discontinue offering certain types of event contracts within the state and having a process by which the trades could be unwound. Now, the CFTC has tried to interfere with that unwinding process, at least in the case of Michigan, by barring Kalshi from unwinding existing event contracts. So there is still some tension between what a state court orders and what the CFTC is willing to allow. But at least in Massachusetts, the precedent and the framework for a preliminary injunction has been established. It's a bar against any future sports-related event contracts, as well as a certain period of time in which those positions can be unwound.
Well, we've been speaking with attorney Daniel Wallach. Daniel, thank you so much for making the time. I really appreciate it.
David, it's my pleasure to join you, and love talking about this issue. Very exciting topic, as this is going to come to a head very soon in the courts, at least in the New York courts, still going on.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.